All right, let's begin this now. Former President Jacob Zuma's corruption and fraud case has been ongoing now for 17 years. Some believe that the sudden resignation of his then lawyers is all part of further delaying tactics. Well, the question is it? And how does one even spot delaying tactics related to court matters? Let's find out with legal expert William Booth. William, thank you for your time. Good morning to you. We'll get into the question around delaying tactics in just a moment. But first, I'm just keen to know, was yesterday's postponement expected? Were you at all surprised at postponement yesterday?
Well, I think everybody was waiting in anticipation to see exactly what was going to happen. After his previous legal team had stepped down, one thought he might have arrived at court on his own and requested a postponement, but he didn't. And what did happen was also, I believe, quite unexpected, that his new legal team requested an adjournment because they wanted to bring an application to court. It seems the prosecutors were not aware of this and indicated in court yesterday quite clearly they wanted time to see what is going to happen and on what basis this application is going to be brought. So, as a result of that, the matter has been postponed.
Yeah, I suppose we're going to find out what some of the details are in their application that have led them to, of course, believe that Billy Downer needs to step aside. But in your opinion, do you think the former president's attorney has a case here against the state lead prosecutor?
It's quite unusual to bring such an application. So in terms of the Criminal Procedure Act, which governs the procedure in all criminal cases, an accused person must plead. And in terms of Section 106 of that Act, there are various options that he has. He can plead guilty, he can plead not guilty. He can raise the issue that the court doesn't have jurisdiction. He can plead, for example, that he's already been acquitted or convicted of the offence. But what is now going to be raised is the issue that the prosecutor has no title to prosecute. So that is also in Section 106. So, it's not something that happens every day. And it would be very interesting indeed to see exactly what is going to be submitted to support such an application that the prosecuting team has no title to prosecute.
Right. William, we've heard the word delaying tactics being thrown around in the past couple of years pertaining to this particular case regarding the former president and, TELUS as a company. In your opinion, are these delaying tactics here, or perhaps for someone who wants clarity and to understand, what would quantify delaying tactics when dealing with such a high-profile case?
Well, look, obviously every accused is entitled to raise objections and to contest aspects relating to the case before the trial starts. That's in terms of pre-trial process. So you're allowed to do that. But I think in this particular instance, virtually every tactic, if I may use that to describe what has taken place, has been used by Mr. Zuma to delay the matter. So if an accused would raise one or two issues and those are then dealt with and either the judge finds in his favour or doesn't, he would have a right of appeal or review. But certainly one has to come to a point when the trial has to start. And if we look at what's happened here, Zuma has gone to various other courts, challenged the fact that there's been unreasonable delay in the proceedings, which is entitled to do, of course. But, I think the public gets the perception with this particular case that it's being delayed unnecessarily. I know the prosecution were ready to kick off yesterday. They've been preparing for a considerable period of time.
Right.
So I think they must be very frustrated with this constant postponing of the matter.
I think the contradiction here as well, William, is that for the longest time we've also heard the former president saying himself that he wants his day in court, he wants to defend himself, but at the same time the date is not coming fast enough, I suppose, even for the public to get some clarity and just to put an end to this matter. With that being said, due to time, what do you think or anticipate will occur then next week, since the matter has been postponed to next week?
Well, the defence have now got to submit to the prosecutors their documents. In other words, on what basis are they going to argue that the prosecutor has no title to prosecute? In other words, the prosecution is not allowed to carry on with the case. So it'd be very interesting to see what are those reasons, what is the basis. So that has to be filed, and obviously the prosecution are entitled to reply, and then the judge would have to hear argument, and I think some mention was even made of evidence being presented, but it's been made clear by his new legal team that he's indeed going to plead not guilty. So I hope this is the end, that these various applications will be brought, they will be contested, argument is presented, and then the judge will have to make a ruling whether there's any basis for such a plea to succeed. If he finds there isn't such a basis, then clearly the trial must commence and the state will call witnesses to try and prove that very many charges, and there are certainly a great number of witnesses. So this trial is going to take a long period of time until it's concluded.
William Booth, we'll leave it there, but thank you so much for your time this morning.